litigators. And if you think about what the litigation looks like, it's a lot of arguing in both the WTO and the investment context over procedural rules, over burden of proof, over a lot of purely juridical concepts that didn't used to exist. This has also made these disputes much more controversial. So that's kind of factor number 2 about why are we all fighting all the time over ISDS. Third, I would say that feeds into why all the fighting over ISDS is the increasing skepticism about trade and investment in general. I would say some of the greatest public skepticism about trade and foreign investment is found in the United States. I was looking at some recent polling data coming out of the Pew Global Attitudes Project, which are pretty stark. They would suggest that in 2002, 78% of Americans held the view that growing trade and business ties with other countries was a good thing. 78%, all right? But then Americans' moods really began to change. By 2007, before the Great Recession hits, the U.S. public's belief in the benefit of growing international business ties had fallen 19 percentage points down to 59%. Tumbles even further down to 53% in 2008. We've recovered a little bit since then, but we are still nowhere back at this notion where 78 or some significant majority of Americans think that increasing trade and investment is good. And I would say Americans are not alone in voicing their doubts about trade and foreign investment. Publics in a number of major other advanced countries, I think, share our skepticism. And I would say that is particularly true in France, Italy, and Japan. Why do I pick those 3? Because they're big and important countries. And if you're thinking about the TTIP or the TPP, I think it's significant to note the attitudes in those. So if you think about it, there's a global median. For example, one of the things that was polled in this is, do you think trade creates or destroys jobs? What do you think? So again, globally, 19% of the people in the world hold the view that trade destroys jobs. 19% globally. But 59% of Italians, 50% of Americans, 49% of the French, and 38% of the Japanese see trade as destructive of employment. So big divergence. Just 21% of the global public hold the view that trade lowers wages. Again, when asked the question, does trade cause wages to go down? 21% of the people in the world answer that question, yes. But 52% of Italians, 47% of the French, 45% of the Americans, and 37% of the Japanese say yes. Trade lowers wages. If you think about it then, if I go to the issue of foreign direct investment. So again, I think Americans share the perspective of publics around the world that greenfield investment, meaning foreign investors building brand new plants from scratch. So the investment consists of, I'm going to put all my money in here, I'm going to buy land, I'm going to build a plant, I'm going to hire employees, I'm going to create this whole scheme. Okay, that kind of greenfield investment. Again, generally everybody says it's good, a good thing, okay? But only 27% of Americans say that foreign-led mergers and acquisitions of domestic firms, in other words, a foreign investor coming in and buying an already existing plant that exists, only 28% of Americans believe that's beneficial to the economy. So, or flip it the other way. 76% of the Japanese, 73% of the Italians, 68% of the French think foreign-led M&A is bad. So again, you have the overlay. So third factor about why is ISDS so controversial these days, part of it is investment itself, foreign investment, is becoming more controversial than it used to be even 10 or 15 years ago. Fifth, I would say, is the other reason why we're hearing so much about ISDS right now, is the shift from bilaterals to these mega regionals. The TTIP, the TPP, even CETA, I would argue, with a big EU agreement with Canada, it's really changed the dynamic. With respect to investor-state dispute settlement, I think it's pretty clear that what is acceptable for many countries at the bilateral level is not acceptable at this multilateral or regional, mega-regional kind of a level. I mean, I think nowhere is this dichotomy clearer than looking at the position of Germany and France with respect to the inclusion of ISDS within the TTIP. So both Germany and France have basically said no ISDS in the TTIP, just absolutely no. They don't want it. They voted. They've indicated that they do not intend to support a TTIP agreement if it includes ISDS. Yet Germany has 134 bits in place, all of which have a very rudimentary form of ISDS with no protections on many of the things that I will go into. So it's pretty clear that Germany has not walked away from its bits or sought to amend or improve them, and yet it says within the context of TTIP, oh no, we're opposed to ISDS. So again, I think the fact that it's been raised to this different stage at TTIP and TPP, again, has caused more furor over ISD provisions. And I think lastly, it would be a number of very high-profile cases that are either pending or have been resolved, and that have been portrayed, again, sometimes I think unfairly, but nonetheless portrayed as real hardcore exhibits of why we should all be opposed to ISDS. One of the cases was mentioned in one of the questions that was asked. I mean, there's two different cases by the Swedish company Vattenfall against the Germans on two fronts. I mean, one is that they had invested in a nuclear facility. Germany made the decision in the wake of the Fukushima disaster that they were going to phase out of nuclear power. So Germany is now in the process of getting rid of all of their nuclear facilities, and here is a Swedish investor saying, wait a minute, you can't, I invested in a nuclear power plant, you can't now change this investment and say I can no longer produce nuclear power. They similarly had another case involving the construction of a coal-fired plant. And again, when the environmental regulations were passed that made it virtually impossible to operate that coal-fired plant, they again sued to say that is a violation of that is taking away, that is an indirect expropriation of my property because I cannot operate this coal-fired plant. So you have these two Swedish cases. You have on our side of the border. Provisions within the NAFTA. We have an ISDS provision in the NAFTA known as Chapter 11, where you have a U.S. company, Lone Pine Resources, that has invested in a fracking facility in Quebec. In Canada, the province of Quebec has banned fracking for environmental reasons. So again, you have a case being brought under Chapter 11 by this Lone Pine, claiming $250 million in damages for the taking, if you will, of their ability to engage in fracking. And sort of the beat goes on. Aloisio mentioned in the opening the idea of the concerns expressed over the lawsuits involving Philip Morris and its desire to be able to sell its cigarettes with that good old Marlboro Man kind of label on it. And Australia has passed a law that says you must market cigarettes in a completely plain package with all of the health warnings about the risks of smoking. And you cannot get a lot of credit for a Marlboro or whatever you want to advertise, must be in a plain package. And again, huge amounts now of litigation under various ISDS provisions as well as within the WTO over whether or not Australia has violated its commitments to ban this idea of being able to use your trademarks. I mean, this is really about can you advertise your products using your trademark. And again, there's more and more of them. I mean, a Swedish company that invested in Romania, and it was provided with some state assistance by the Romanian government. When Romania joined the European Union, the EU says, no, you can't give that kind of state aid anymore. I mean, you're no longer that kind of an economy. You're going to be a market economy, no more state aid to any of these companies. The Swedish company says, wait a minute, I'm bringing an ISDS action because I was promised this state aid. So again, and again, rulings coming out saying, if you, again, an ISDS ruling that if a state discontinues business incentives in order to bring its policies in line with the EU, the foreign company can claim that its rights have been violated. And again, more and more of these, but I'm just saying there is now a significant number of these fairly high-profile cases that have raised this whole issue of ISDS to a level that we've never seen before. So what are all the critics saying? I mean, what's all the shouting about? What are they saying, and what do we make of it? I personally think that the challenges to ISDS fall into two camps, if you will. Maybe that's overly simplistic, but I think it's, to me, the way they fall out. For the critics, if you will, on the political left, I mean, what they'll say is that the ISDS is wrong because it gives corporations excessive powers to be able to sue democratic governments when those democratic governments are taking decisions for the common good, such as environmental regulations or health regulations or others. They would contend that ISDS allows corporations to sue merely for the loss of profits, that it permits cases to be heard in secret in the jurisdiction that's been chosen by the corporations as the most favorable to it, that that these dispute panels are going to take into account free trade values, more importantly, while disregarding the values of public health, of human rights, of environmental protection, of labor, or other social rights. So again, that it's tipping the balance way too heavily in favor of the investors, and it's giving the investors a right that they would have nowhere else, which is the ability of an investor uniquely to be able to bring an action directly against a foreign government. Then on the other hand, I think there's a fair number of libertarians or others that would say that the ISDS is fundamentally not necessary, particularly not in the TTIP. And these would argue that ISDS is really overkill, since the major multinational corporations, which are the ones who are engaging in all of this investment, are big players. I mean, they're big boys. They are certainly big enough and savvy enough to manage their own risks. They don't need some kind of separate dispute settlement mechanism to protect them. That when we insist on ISDS provisions in a negotiation, that we are paying for those provisions as part of the bargaining of a negotiation, and may not be getting as much results on market access or other things that we might want because we've got to pay for the ISDS provisions. Some would argue that ISDS could have the effect of neutralizing the benefit of developed markets like the United States or Europe's market. Because one of the things that we have to sell to investors, why should you come here and invest in the United States? Come here because we have a rule of law. We provide significant respect for private property. Come and put your plant in the United States of America where you can be very comforted by that. If you now include ISDS that has the same, if you will, provisions all over the world, have you in essence cheapened the value of an investment in a market like the United States, they would argue. Others would argue that that ISDS can in many ways exceed national treatment. I mean, the whole system was started on the basis of non-discrimination, MFN and national treatment. And yet when you think about it, if you're now going to give a foreign investor access to a privileged tribunal when a domestic company has to go through national courts that may take a lot longer. You get in the pine that at the end of the queue in a civil law dispute these days in the United States, 4, 5, 6 years. You may be in an ISDS proceeding as a foreigner and get much, much, much faster, if you will, resolution of your dispute. So it is in that sense privileging national treatment in favor of foreign investors. And bottom line, I would say in TTIP at least, people contend that both the US and the EU already have high standards, rule of law, and very sound courts. So why do we need an ISDS new system of settling disputes if the courts are already set up and can handle it just fine? There are many, many other arguments that are being made about ISDS, but I thought I would take sort of two of the major complaints on the substance side and two of the major complaints on the procedural side, just to talk a little bit about where is all of this discussion going, and what might we make of it. And the two I'll pick on the substantive side to sort of frame our discussion is, I'm going to start with the issue of indirect expropriation, because this is clearly one of the really controversial issues. Again, if you think about it in general, there's, as I said, starting from way back customary international law notions, expropriation provisions in investment chapters and treaties that determine in which situations a state has to compensate effective rights holders for taking property by the state. So the investment treaties allow states, they say, yes, states, you can expropriate property, but it requires, one, you got to compensate for it. And again, so there's going to be always a lot of pushing and shoving over how much is that compensation. Secondly, the expropriation has to be for a public purpose. Third, the expropriation has to be non-discriminatory. You can't simply go after certain property and not others on a discriminatory basis. And fourth, it has to be done in accordance with due process of law. So that's all fine and well with respect to expropriation. But the issue of indirect expropriation arises when a regulation or law is seen by an investor as effectively taking their property. Property's still there, but they view it as effectively taken. And again, this comes up most often in the environmental context. I invested my money in this mine. I was intending to mine. You have now passed a regulation that says that the wastewater coming out of the mine has to be so clean that it's made it impossible for me to mine. So now I can't do anything with my mine. I'm just going to have to let it sit there. You have indirectly expropriated my property. That's the argument that's being made. So it definitely raises the concern of why should citizens have to pay a private investor because their government has chosen to regulate the wastewater coming out of this mine. I mean, again, a lot of citizens would say, good for my government. You've done exactly the right thing. You've given me cleaner water by regulating the effluent coming out of that mine. Why do I now have to pay as a citizen in order for you to do that? So again, there's a huge issue over how do we define what is an indirect expropriation and whether there should be this general notion in ISDS of when it happens, you have to pay compensation as if it were the same thing as a direct taking of property. Should they be the same, regulated the same, provided for in the same way? Again, I would say in the CETA, and you may have heard about this, and I apologize if you have, obviously the EU and Canada really did seek to address this by including a case-by-case analysis that would try to show exactly when an indirect appropriation has occurred and when it has not. So again, they're trying to use by example. This is indirect expropriation, this isn't. And to make it clear that the fact that a measure increases the cost for investors does not give rise to a fine of expropriation. So in my mythical mind, just because it might be more expensive to clean the water does not mean that that was an indirect expropriation. It includes, for example, in the CETA, this annex that specifies that certain measures do not constitute an indirect expropriation. It carves out the notion that non-discriminatory measures to protect legitimate public welfare objectives, such as health and safety, are not compensated at all. In other words, that governments are entitled to do that. I would say even the harshest critics of ISDS would say that this language in the CETA is a great improvement over the traditional bits, including all of these ones that the EU member states are in. But I would personally say it remains to be seen whether these limits on indirect expropriation can really be implemented. I mean, whether you really are going to see tribunals saying no compensation because this is not effectively an indirect expropriation. Second issue that I'll touch on is another one that's quite controversial on the substance side, is one called fair and equitable treatment. So there's always been perceived to be sort of three pillars of every investment agreement. You can't discriminate on a national treatment basis, you can't discriminate on an MFN basis, and you cannot engage in unfair or unequitable treatment. So again, it's one of these pillars that's always enshrined in almost every investment treaty. It's also the single most widely invoked standard in investment arbitrations. So whenever you see an investment arbitration being invoked, chances are very high that the number one complaint is, you violated my right to fair and equitable treatment. That's what everybody complains about. The problem is that it is very broad and vague wording in terms of what do you mean, what's fair and equitable treatment? And tribunals have literally been all over the map in their determinations and in how they read and interpret this concept. So there is great uncertainty over what actions are going to be considered to be a violation of fair and equitable treatment standards. And the fear that the standard can be used as a tool to force states to pay for the development of law in the public interest, where changes in the law or its implementation leads to increased costs or reduced profits for the investor are very real out there, given all of the very, like I said, disparate findings that have been made. So there's a lot of approaches to try to address this issue, including more specific definitions of what is fair and equitable treatment. In the CETA, for example, they specifically say that a breach of fair and equitable treatment can only arise, and then they again list out 5 very specific things, like where there's been a denial of justice in criminal, civil, or administrative proceedings, where there's been a fundamental breach of due process, where there's been manifest arbitrariness, where there's been targeted discrimination or on manifestly wrongful grounds, where there's been abusive treatment. So again, on the one hand, you can say all of those things, and on the other hand, there still is an issue of judgment. What do you mean abusive? What do you mean manifest? What do you mean? Again, so even within these much more precise statements, you still have a lot of wiggle room, if you will, for everybody to argue over what do you mean is a fundamental breach of due process? What is a manifest degree of arbitrariness? So again, I think a lot of efforts to it, but not clear exactly where they're going to lead. I mean, it's not clear to me that these limits on the treatment will work, or whether the concept of fair and equitable treatment needs to be eliminated altogether from these kind of ISDS provisions. But those are just two of the many kind of substantive areas. If I flip over to the procedural side, there's at least as many procedural complaints about ISDS as there are substantive complaints. So one of them, first one, is often on the lack of independence and impartiality by the arbitrator. So virtually every arbitration agreement, says, in essence, there will be 3 arbitrators. And normally they are to be selected by the parties. And what happens in reality, and in almost every case I'm aware of, the investors put up their arbitrator, the state puts up its arbitrator, and then all of the pushing and shoving is over who is the third, and usually the presiding arbitrator over that. And the problem is that the arbitrators that have been promoted by the investors feel almost, I think, somewhat degree of duty bound to side with the investors. Those arbitrators that are promoted by the states tend to be those that are going to decide the case in favor of the states. And so it all comes down to who is your third arbitrator. And again, the third arbitrator can often and is often agreed upon by the parties. If not, the default is often to an organization like ICSID or other places. And again, in the CETA, that's exactly what the EU and Canada did. Same old process, but if you cannot agree on one or more of the arbitrators, then the ICSID Secretary General, again, who's in theory neutral as between Canada and the EU, she happens right now to be a Canadian, but we'll leave that out. Let's assume the ICSID Secretary General is going to appoint a fair arbitrator. To me, part of this stems from the fact that unlike in other judicial settings, many of these arbitrators are an arbitrator today, and tomorrow they're an advocate on behalf of either an investor or a state. And the conflict rules, in my own personal judgment, are quite weak in terms of whether or not that represents a conflict. Because the notion of conflict tends to be fairly defined by a financial conflict of interest. Are you being paid by one party or another? And that's, to me, not as much the problem as what I would call a positional conflict. I mean, if you have spent all day today arguing that the words fair and equitable treatment mean something very broad, and tomorrow you're now an arbitrator and you're hearing an argument that the words fair and equitable treatment need to be read very narrowly, are you genuinely open-minded, impartial, and unbiased? Or did you believe what you've been arguing about all day yesterday? I mean, did you believe your own advocacy at some level such that you are no longer an impartial arbitrator? I mean, to me, there's a lot of ways you could resolve this issue if you wanted to. I mean, one of them is you could simply say nobody that litigates can also serve as an arbitrator. You create a collective list of arbitrators. You must choose an arbitrator from the list. You can't have the parties just picking whoever they want. We're going to just establish a cadre of professional arbitrators who that's their job, that's all that they do, and they're not, if you will, paid by either the investors or the states. In any instance, they're paid by their institution. So a lot of ways you could skin that cat, but that's a clear issue out there that has not been resolved. And the last one I'm going to talk about just really quickly is transparency. Again, coming out of their sort of diplomatic past and in light of the sometimes significant amount of confidential information that can be involved, investment arbitrations have often, in fact usually, been among the most secret of all of the international juridical proceedings, with everything from even the existence of the arbitration, the names of the parties, much less the proceedings, the awards, etc., are often completely secret. So you can't even figure out who's arguing and what they're arguing over, much less what the outcome was in an awful lot of them. So again, much of this has been kept out of wraps. The ICSID rules and the old UNCITRAL rules, among others, really did allow for this hyper degree of secretiveness about these proceedings. The good news here is, I think, particularly the US and Canada, I will give them a lot of credit, have really led the way towards bringing a lot more transparency. So all of these secrecy things generally are not true in Chapter 11. You can find out a lot more what's happened in NAFTA disputes under investment rules. And UNCITRAL itself came out with new transparency rules which became effective on April 1st of last year. And this does say that, again, the proceedings need to be open. And within the CETA, again, the new rules between the EU and Canada are now going to say that all documents, submissions by parties, decisions of the tribunal are going to be publicly available on the website, that the hearings are open to the public. So if you're willing to travel to whatever far-flung spot they might be in, you can sit in on these proceedings, that interested parties, including NGOs, can now make submissions in ISDS proceedings under the CETA rules. This is a sea change in terms of transparency of where it's been. I'm going to conclude. I apologize for going longer than we should have, but to me, I think there's no question that the inclusion of ISDS provisions in the TTIP and to a lesser extent the TPP will be, I think my own view is the single most controversial item in these negotiations and most likely the very last of them to be settled. Negotiations would be sort of over not only whether to include the provisions at all, whether you should have ISDS at all, but also within the text of them, whether you can make some meaningful changes in what has been regarded as sort of fairly standard ISDS rules. Whether the CETA presents a new model or whether any of these negotiations will incorporate changes that will allow them to improve, I would say, over the status quo. And to me, that's really, as a policy matter, the sort of dilemma. Are we better off with no ISDS in any of these provisions, in which case, what's the fallback? For many, the fallback is to their bilateral bits, and in almost all of these bits, I will tell you, the ISDS language is terrible. I mean, it has zero transparency. It has zero of any of these things that you might want. It has zero limits on fair and equitable treatment, etc. So the question is whether you want that. That's one fallback. Another fallback is obviously the national courts of each of the countries for investors to bring lawsuits in the national courts. And again, varying degrees of what would come out of those national courts. The flip side of it is to figure out whether or not you could craft ISDS language that would meet a lot of these concerns that have been expressed, that would be really, truly a better approach to settling investor-state disputes than what we currently see on the table. My own hope is that I think there is at least an opportunity to use the TPP and probably more likely the TTIP to do exactly that, to come up with real 21st century rules on ISDS that restore a real balance between the needs of investors for protection with the needs of states to be able to regulate whenever they need to engage in that kind of a regulation without it being considered a taking of an investor's property. And I think it does represent an opportunity to do something really novel that would again restore that balance, and more importantly, going back to where I sort of started from, restore sort of general sense of confidence in the trade and investment regimes writ large. Because my concern is that as we go further down this road and there's more skepticism about trade and investment, we all need to put in place the rules and the systems that will leave everybody, from the private investor to the labor union to the NGO, more confident that the rules are fair and balanced. So it would be my own personal hope that that's where we might end up. But hopefully that's given you a little sense of where we are on ISDS.
Well, thank you, Jennifer. It was not a little sense. It was a lot of sense. So much information. And do we have time for questions? We have one.
5
right.
minutes? Yeah.
5 minutes? All right. Udi, a short one.
You need a microphone, though.
Who's pushing then for the ISDS? Okay. Yeah, for the lifestyle. Who's pushing for the ISDS? Because you said the bids are already there, okay? So between the US, EU, presumably with most of the TPP partners, the US has these bits already. You're saying that the language is terrible, in inverted commas, meaning there's no transparency required, the provisions are very broad, etc. So who is pushing? I mean, are big companies in the US and Europe pushing for it? And if so, why?
I think the push is both from the governments and from some of the investment community. Part of the push from the governments, particularly if you think about it within the TTIP context, I mean, you could have heard USTR Mike Froman say that you could never regard the TTIP as a high standards agreement if it didn't have ISDS in it. Part of it is the perception that if you don't have ISDS in TTIP, it's very hard to see how you would get ISDS in many other agreements. So again, the argument made in TTIP most often is, look, the courts of Europe and the United States are already very strong. You already have more than whatever it is, $4 trillion today cross-invested between the U.S. and Europe. So it's hard to see how you can argue that U.S. investors are so afraid to invest in Europe or European investors are so afraid to invest in the United States because they're not sure they're protected. $4 trillion has already moved, so that's $4 trillion speaking for that level of confidence. But the perception is, if you don't put it in this agreement, then what does it say when you want ISDS in another agreement? What it says is, okay, I trust the European courts, but I don't trust you, and I don't trust your courts. Brazil, I don't trust your courts. India, I don't trust your courts. China, I don't trust your courts. So the perception is that would be perceived from a sort of foreign policy political standpoint as fairly unacceptable, that we insist on ISDS in other agreements, but not with the European Union. That, at least from the United States' perception, I think is really not acceptable. And I do think there remains a big push from the investor community because they want, again, remember the default is maybe not a bid, it might be national courts. What most of the investors want is they do not want necessarily to be told that their only remedy is within the national courts of a given state. They like this privileged sort of mechanism where they can bring actions directly against the states. So I think there is some significant push among the investment community, and it's partly because they have it in a lot of other agreements. And so the notion that you would enter into this big TTIP agreement without it is considered, to many of them, fairly unacceptable.
Quick question. The trend has been recently away from BITs. We had South Africa, as a result of this conference I mentioned, decided to let everyone expire. Singapore is going to have let everyone, all BITs expire. Indonesia is doing the same thing. Same thing in South America. There's a trend going on. This all happened in the last year or so. What is that telling us?
Well, it's interesting because while at the same time that's happening, that there is this move away from some of these bits, at the same time, you now have, again, this, as I talked about, this sort of reintegration of trade and investment in all of these sort of mega regional agreements. So certainly in all of the United States' trade agreements, you now have investment provisions being brought in. So they're maybe not being done on their own footing as a separate investment agreement, but a lot of the trade agreements are now including investment chapters and ISDS as part of a trade agreement. So some of it, it's a kind of counter push where you're seeing it in the other way. And I think it's too early to know whether countries in the end are going to say, we want investment. We want disciplines on investment. We just don't want ISDS. And that's what I think is not clear to me, whether you'll see people coming back to having bilateral investment treaties, but what they won't have is this separate mechanism that allows directly an investor to sue the state. Or they may come up with a different dispute settlement mechanism.
I think you're absolutely right, because the reason they're running away is ISDS.
I don't think it's the notion that we want the right to discriminate or we want the right to violate MFN. It's more we don't want disputes. We do not want investors to have the right to sue us.
Any questions?
Are you aware?
How are you, sir?
Good, how are you?
Good to see you.
Good to see you. Are you aware of, specific ISDS outcomes that validate the concerns that the investment provisions, whether in BITs or NAFTA or elsewhere, have in fact prohibited legitimate government regulation?
Again, I don't want to say a number of the cases, the problem is they're being talked about but have not yet been resolved. A number of the cases, the outcomes are not transparent. I mean, the first one that I'll mention, the first case that I mentioned of this Swedish investor in the coal-fired plant in Germany. Again, so Germany passes the regulations to say on coal-fired plants. That went into an ISDS dispute, and all we know is that it was resolved amicably, if you will. It was settled, and you don't know exactly what was done. I mean, whether the Swedish investor was paid off, whether the Germans lessened their regulations on coal-fired plants. It's not entirely transparent at this point what's happened. It's clear that some of them have no doubt resulted in, again, I've got a whole list, but I mean, some of them have resulted in fairly significant payouts. There are some. The problem is it's really hard to study whether there was other things that went on in them that would suggest it. I mean, one of the biggest ticket ones, Occidental in Ecuador. Highest compensation award ever to an investor in an individual dispute, $1.77 billion awarded to Occidental, where what Ecuador had done is terminate the contract for their oil concession with Occidental after Occidental sold a lot of its rights to another company without complying with all of the various regulations as specified in the contract. So it's a bit of an odd dispute because it's not really about environmental regulations. But again, Ecuador, another huge one was Chevron, where there was a whole series of these pools of waste water it wasn't originally started by Chevron, but from Chevron's facility that was causing tremendous damage to the human beings that lived around that water. In other words, it had destroyed the quality of the water. So a judgment was rendered against Chevron. And then that judgment was trying to be enforced in New York, as most judgments are under the New York Convention. And huge litigation. I mean, Chevron just said, look, we're not paying under this judgment. They hired literally 400 lawyers and said, we will fight to the death and will not make this payment. So here is an issue in which the state won on environmental grounds, and it's now finding it impossible to get that judgment enforced. So I do think there are plenty of them out there that would say this, but the vast majority of the cases that people are talking about just frankly haven't been resolved yet. It doesn't answer the question, though, because one of the other honest complaints by many states is, yes, but right now, most of the rules in most of the ISD systems say everybody pays their own costs. So even if the state wins, if it has had to spend $20 million hiring private lawyers to litigate on its behalf, $30 million, whatever, in order to win the case, it is still $20 or $30 million out of pocket just by the mere existence of this case. So among the other procedural things that a lot of people think need to happen is the ability to weed out frivolous cases and the ability to shift costs to the losing party so that states are not constantly paying simply to defend themselves and to defend their right to regulate. So I will tell you there are a lot of fairly good, on Chapter 11 on the NAFTA disputes, there are fairly good analyses that lay out every case and sort of where it all comes out. But because a lot of the rest of them are not transparent, it's much harder to do that for the rest of them.
Please join me in thanking our keynote speaker today, Jennifer Hillman. Thank you all. I think the show continues. All right.
Let's see if it's still on, first of all.
Two are modern and one is not.
Well, are you going to be talking about safety? Yeah, okay.
Yeah.
It's fine. I'll present it as these are all sort of modern new issues. I was just going to go in the order that if we were on the sheet. Okay. That's great.
One person was missing on this.
Yeah, that's right. She took some of his stuff, yeah. I mean, she was referring to libertarians, and I think it was more from him than from me. So yeah, so
I was just reading.
yeah. Okay. Oh yeah. Okay. Good to see you. All right. You got Alistair, Sean,
Hi, Mr. Chair.
Josh. Oh, okay. That's yeah. Now. Yep. One on the other.
Do you know where the rest of the water is? Did they all go?
No, they're all headed. Oh, Michelle. Not that many.
For those of you who are on live stream, we are finished with our keynote, and we are also commencing to do our third session of the day, which is on sectoral. We've had one or two questions for the panelists from the live stream, and we will try and answer those in the Q&A. Thank you.
Going in this order here. Yeah, the lights keep glaring down. Yeah. I feel like that happens a lot at Cato Institute. It's even worse. They just Well, welcome everyone to the second panel of the day. My name is Simon Lester, trade policy analyst at the Cato Institute. I also run the website worldtradelaw.net for you lawyers out there. So I wanted to start by saying, you know, when I was starting out in this field as taking international economics courses as an undergrad and then studying international trade law in law school, it was a much different time. There were certain core issues that you studied, and if you understood those, that was all you needed. So the formulas for negotiating tariff lowering or calculations of dumping and subsidies or understanding like products in the context of GATT Article 3. And if you knew all that and you could talk about all that stuff, you were pretty much set. That was the field. But as I was studying it and then moving to the work field, things changed, and all of these new issues started coming in. And all of a sudden, you realized that you needed to go beyond the traditional trade issues to understand what was going on in trade negotiations. And that's sort of what we have here in this panel when we have these sectoral issues that we're going to be talking about. We'll be talking about intellectual property law and food safety law and data privacy and data flows. And it makes me wish that back in law school somebody had told me, you know, you should take a patent law class. That might be helpful for you. So we're all trying to play a bit of catch up and trying to figure it out. And so I think that this panel here will help us in that regard and sort of catch us up on some of the issues that have become most controversial in all of the mega regional trade agreements. So let me just briefly introduce each panelist. We'll maybe talk for 15 minutes, 10 or 15 minutes, and then hopefully have some time for questions at the end. I'm not going to give you the extra long bio. I'll just give you sort of a basic one. We have Sean Flynn will be going first. He is a professorial lecturer in residence and the associate director of the program on information justice and intellectual property at the Washington College of Law here at American University. Next up, we'll have Alistair Young, an associate professor and Jean Monnet chair at the Georgia Institute of Technology's School of International Affairs. And then last, we'll have Josh Meltzer, a fellow in global economy and development at the Brookings Institution and an adjunct professor at the Johns Hopkins School for Advanced International Studies. So let me just turn now to Sean Flynn, who's going to be taking us through some of the most controversial and very difficult to understand intellectual property issues, but I know he'll explain them in a way that we can all understand.
Thank you for having me here, and it's great to be here with Simon for the last year and a half or so. I've been in the very pleasurable stance of being completely in agreement with a member of the Cato Institution, which is, as the luncheon speaker was describing, kind of the far left and their approaches. I ascribe myself to a lot of those views generally, but there's a convergence now in the trade realm between the far left and the far right on a lot of the critiques that are going on, especially in my field, which is international intellectual property. So I'll try to describe some of those concerns. So this is going to be a critical reflection of the role of intellectual property within free trade agreements. And then I think, at some point here, we may have more of a conversation. Simon and I started some discussions around transparency and trade agreements outside that maybe we'll have a moment, a chance to bring out at this table. So, I think the basic point I want to get across here, I suppose, to be very blunt about it, is that the issue of intellectual property is really not about trade. It is certainly not about traditional trade. It has not normally been negotiated within trade agreements. It's extremely new. It's extremely controversial, and I think justifiably so. I think it's in the wrong place. It's really about substantive regulatory harmonization. And there are reasons to do substantive regulatory harmonization within intellectual property. We've been involved in international intellectual property and the formation of these standards for 150 years. The basic concern is about free riding, right? So if you go back to the 1880s and the formation of the Berne Convention, one of the oldest and strongest intellectual property agreements in the international field, there was a concern that granting a copyright in France but then not respecting it in Germany would deprive the author from France for the just royalties that he should get in Germany. Same with patents. So you give a patent in France but not in Germany, and somebody can just knock off the product. And it was really, those two conventions really started as European agreements. They brought in some of their satellites. Developing countries were largely represented through the colonial structure at that point. It was really about a close market that was functioning as a relatively close market at the dawn of industrialization. So we're talking about the 1880s. Cross-border trade is really about cross-European border trade, and what should be the kind of the harmonized intellectual property rules within those borders. And those agreements gradually through the history of over the last 120, 140 years or so have grown to include now almost every country in the world, to form a whole new institution, the World Intellectual Property Organization, which has negotiated, 40 or 50 other international agreements on intellectual property. But those agreements are all multilateral. Any country that wants to be a member of a negotiation within WIPO can. That doesn't mean all do. There are agreements that are originally formed with maybe 40 or 30 countries. Often the actual negotiating parties are a smaller number. But anybody that wants to see what's going on, to participate in that negotiation, any country can do so. So the problem that was alluded to before on the first panel of how can you negotiate what you're claiming to be a new global standard, but then not include like India and China and Brazil and South Africa, like even in the room, that doesn't happen within the World Intellectual Property Organization. If India wants to be in the room, it can be in the room. If it doesn't want to sign the agreement in the end, it doesn't have to sign the agreement in the end. But the legitimacy of the enterprise is in part bolstered by the fact that any country that wants to be in the negotiation can be in the negotiation. And secondly, and this has evolved over time, WIPO negotiations are incredibly transparent to civil society. So if you take the last negotiation, the Marrakesh Agreement on copyright limitations and exceptions for people who are blind and have visual impairments, every meeting was actually televised on the internet, broadcast, and they even, and that's been going on for quite a long time, every proposal from any country to amend the operative text is literally tabled. There's a version of it, and it's put on a table outside, and any accredited NGO, you have to be accredited, but it's not very difficult, can see the proposal and can comment on it and can actually be in the room where things are being negotiated. And so that kind of diplomatic relationship that was being discussed over lunch, where people know each other and talk with each other and deal with each other, actually takes place between civil society and the diplomats, as well as, and civil society, I mean broadly, right? It's corporate interests and it's public interests. You know, it's all kinds of different people are in the, literally in the hallways. I've been in those hallways, and you know, people come out, negotiators come out, they get approached, and meetings are happening on the side, and this is all part of the way the game is being played. That approach gives the product a certain kind of legitimacy, right? Like the NGOs are in the room, the public can be in the room to the extent they want to, any party can be in the room. One argument is that it slows down the process, and the question is, well, is that good or is that bad? Sure, it slows it down. You got more players, you got more interests involved in the process, which is going to lead to a slower process in the end. But it also, I would argue, would lead to a more balanced process in the end. You know, so if you look at the Marrakesh Agreement and the public statements that came out when that agreement was signed, both the MPAA, the Motion Picture Association of America, who the public interest groups see as kind of, you know, the Death Star, right? You know, only constantly more and more copyright, never seen a copyright law we didn't like. And then like Knowledge Ecology International, which, you know, to the MPAA is like, you know, the former Stalinist Russia. Like, they both came out with comments that this is a balanced product of a balanced and legitimate process. Both sides, polar opposite sides of the spectrum, come out and praise the end game. And there's something in that agreement that both parties like and don't like. So we fast forward that system as the center for intellectual property making is still going on, but the plurilaterals and the bilateral agreements are competing to be the center of where this kind of policy making happens. And it's happening through an incredibly different process. So it's the trade agreement process, the original bilateral trade agreement process, was erected for the core purpose of negotiating tariff barriers, right? Lowering tariffs and traditional trade barriers. And as Cato's like excellent work, you know, and some of the stuff that they've been putting out criticizing the place of intellectual property in these trade agreements has mentioned, there's a political economy justification for having a more closed-door kind of bilateral country-to-country process for those kind of agreements. And the reason is you're actually trying to set up a process that sets interests in opposition to each other. You know, you want the protectionist interests within your own country of political power to be offset by the importers and the exporters in both countries. You know, so I was at a meeting at Cato where they were saying, well, we would rather have everybody just unilaterally bring down our barriers. We think, you know, from our libertarian economic standpoint, that that's going to be better for everybody. But because of political economy reasons, nobody's going to do that. You know, the sugar industry is going to, you know, be hardcore against you if you try to set up that process. So you need a different political economic process to set those interests against each other, so that in the end, barriers on both sides go down to the benefit of consumers, right? So now think about the purpose of intellectual property regulation. So it's the exact opposite, really. There's only protectionists on the side of intellectual property. It's about producers in some countries trying to extend a monopoly advantage in another country, and there is no similar force in that other country that's pushing back and achieving a level playing field. So when you bring it in to this debate, what you're really talking about is trading one side. We'll lower our agricultural tariffs if you raise your intellectual property protections. We want you to pay more for our medicines in order to get more from our agricultural side. In addition, intellectual property is very different in that it doesn't just affect kind of the tariff levels of discrete industries, right? It really affects us all. You know, it goes from the prices of your medicines to the prices of your textbooks to what you can do on the internet. It's extremely broad regulation. And so because of that, even if you were going to consult with like a small number of industries on the tariff side, so the fact is we actually don't keep tariff negotiations secret from the companies that are affected by them. We have a specific industry trade advisory system that consults with them extremely closely. The only people who aren't consulted in the traditional tariff and trade process is the broad consumers, but we see them as being, in the traditional theory, as being benefited by the entire process. So now you move into IP. We have an industry trade advisory committee system which is stocked full of media conglomerates and pharmaceutical companies and one representative of a generic industry and one representative of a technology internet company, which is really a legacy telephone company. And those are the only people that get to see the US proposals of text as it goes forward. The rest of the United States and the consumers and everybody from every country that's going to be affected by the agreement doesn't get to see it until it's done. And then ideally, from the perspective of the USTR, et cetera, that there would then just be an up or down vote in Congress with no ability to change the outcome of the deal. Or, as was the example in the anti-counterfeiting trade agreement, the last big plurilateral intellectual property trade agreement, the official position of the U.S. administration was that it doesn't even have to go to Congress at all. Although the international effect is a binding treaty, it would bind the United States to not change any of its intellectual property laws without violating or renegotiating the agreement. The argument of the administration was it doesn't technically change U.S. law, and therefore it doesn't have to go through Congress at all, either through the treaty clause or through as a congressional executive agreement. So there will be no input from congressional representatives, even on an up or down vote at the end of the day. Now, the product of this kind of negotiation has been very unbalanced products. So you will find provisions within those agreements that don't reflect the same kind of policies that would come out if you put them through an open process. When you open the process, the substantive policies change. So, for instance, the TPP is 30,000 words as opposed to the WTO TRIPS agreement, which is about 10,000 words. It includes 256 footnotes. It includes a huge number of areas where we bind ourselves to some of the most controversial areas within U.S. law. One that may be familiar, patent evergreening, for instance. The ability in the US, you can get a patent on a new drug, and then when the drug is getting ready to go off patent, you can get another patent for any new use of that drug or any new form of that drug. So there's a company I'm familiar with that has an Alzheimer's drug right now, and they're switching from a 2 or 3 day formula to a once-a-day formula, and they're going to take the old one completely off the market, repatent the new one, and then try to maintain its market power over that market that way. So other countries say, well, fine, you want to do that, but we're not going to have it. So India passed a new patent law that says you can't get a new patent on a new form or a new use of a known substance unless you prove that it has an efficacy bonus. So now you go over the TPP. So guess what the TPP says on that issue? You have to give patents on a new form and new use of a known substance, even if it does not have an efficacy bonus. So it's the exact opposite of that kind of agreement. So it brings it all together. So India's not at the table. You've got a policy that's directly targeted at India. This is a new global standard agreement that we assume that we want everybody to be part of. The only reason I know about it is because it leaked. The public health groups, AARP, et cetera, that care about this issue officially haven't seen the text because the only way they can see it is leaked. They're not part of the Trade Advisory Committee process. This is a process designed, I would say, probably consciously, to achieve an industry capture over the process. And we have to remind ourselves that what's being negotiated is binding international law. So even if it doesn't change U.S. law on a subject, it binds us not to change U.S. law on that subject without violating the agreement. So now you're AARP and you want to get rid of the patent evergreening rule. You can't do it unless you convince Congress to demand that USTR renegotiate 17 different bilateral agreements that already have that provision in it. So this is kind of the state of where intellectual property within these agreements is today. And a quick, kind of comment on the future. So where do we go from here? I would argue, and I thought it was very interesting listening to the different panels this morning, that trade more generally, but IP specifically within trade agreements, is in a state of crisis right now, that the institutions need to be rethought out. And the reason they need to be rethought out is because they've been drawn up by just trade attorneys without enough conscious attention by the rest of us. So investor-state dispute settlement is definitely in play right now. It's a huge debate. It's finally coming to surface. So you have public statements by both USTR and European Union negotiators that, okay, we hear you, we're going to try to do something about it. But unfortunately, they're trying to do something about it still, cloaked in this secrecy. It's not enough of an open process to really figure out how we should change it. Intellectual property, so the last big intellectual property plurilateral agreement that was negotiated like this was ACTA, the Anti-Counterfeiting Trade Agreement. ACTA was voted down in Europe by a vote of about 430 to 30. 300,000 people took to the streets after it was finally publicly released to march against the agreement. I mean, this is intellectual property that is, as Simon described, it's like complex and impossible to understand. Here's what people understand. It affects us. And you didn't involve us in the process at all. Our representatives, our organizations, nobody that we care about. So they see it as people see it as a captured, non-transparent, illegitimate process. And if TPP goes that way, my prediction is TPA, it's Trade Promotion Authority, goes down in the House. The bill that's marked up in the Senate is going to have a lot of interesting amendments, and it's probably not going to pass the House because people don't want to vote for something authorizing the president to finish an agreement that they don't have any right to see. And right now, as it is now, only members of Congress, but not their staffs, have the ability to see the agreement. Well, members of Congress don't read agreements. It's their staff that read the agreements. So if you don't share things with their staff, you're not sharing things. So Congress is not feeling very good about the trade process right now. So I think this process, especially on intellectual property, it looks very stalled to me. Even if it passes, what you have is this battle between spheres. So China is not in the TPP. This agreement started with China. It started in APEC. The idea was to have an APEC-wide Asia-Pacific trade agreement. So the United States, actually the original agreement was the P4 agreement, which was New Zealand, Chile, Singapore, and Brunei maybe, created a pure free trade agreement that I'll bet Simon loves. It just says all of your tariff barriers, you have to reduce them to 0. And its IP chapter is 1 page. You shall cooperate, and you shall implement these 3 or 4 provisions of the latest WIPO treaty, a treaty negotiated through the WIPO Forum. So there's a trade agreement. It's just about trade. So China has picked up, and it's saying, okay, go do your TPP negotiation, but at the same time, we're going to have an Asia-Pacific free trade agreement, and we're going to negotiate it with no IP chapter. And it's going to have all the same parties. So Chile, all the rest of the TPP members are there, but it has China, huge country, right? The U.S. is not part of it, and they're going to negotiate a new free trade agreement that'll have no IP clause, and you'll be able to choose which one goes forward. So either there'll be this battle between spheres, and both spheres will have their own rules, and then it'll be to decide, where's India going to go, right? Where's South Africa going to go? Where's Brazil going to go? Where's Argentina going to go? So the U.S. has constructed its spheres through these, 1727 or so different bilateral trade agreements, but it's not the governing standard for the globe. The question is, where does the rest of the globe really go? Are we going to have these two big spheres, one run by the U.S., one run by China and India, or are we going to truly have a global agreement where we bring everybody together for similar standards? And if we do, what's the process that we're going to use to create that standard? And what's the outcome that we want to achieve? Is it to bring everybody to the U.S. intellectual property rules, so everybody has to have the Digital Millennium Copyright Act and notice and takedowns on the internet, et cetera, 70-year copyright terms, unlimited patent extensions even for existing products? Or is there going to be a different set of standards that more closely parallels, for instance, the World Trade Organization, where you have to have patents, but you don't have to have patent extensions. You have to have copyrights, but you don't have to have them for 70 years. So are we going to have one size fits all, or are we going to have a true kind of minimum standard above which people have or countries have a very large degree of diversity? And that's, in short order, I think what the big debates are in copyright, or in IP and trade today. Thanks.
Thank you very much, Sean. That was a great discussion of some of the details of IP, and then also put in the broader context of international relations. Let me turn it over to Alistair now for some talk about food safety and agriculture.
Thank you very much. I'd like to thank Michelle for inviting me here to what has been a very informative session for me. I will be even more grateful if I get home tonight.
You'll be fine.
Now, at the beginning, Simon was saying trade is different now. And in some ways, agriculture is the truly traditional trade issue. And historically, it's been the problem area for free trade agreements trying to meet the WTO's requirement that trade covers substantially all trade, because people don't really want to talk about agriculture. But perhaps paraphrase Simon, we're not talking, agriculture is no longer your father's trade policy. There's now much less concern about not including it in agreements. There's much more ambition than in the past, as Colin Bird alluded to this morning. But it's still problematic, but in some ways that are not what we're used to, and in particular, issues to do with food safety and also intellectual property. The agricultural issues have changed somewhat. It used to be all about domestic subsidies. Domestic subsidies are no longer a big deal in either CETA, TTIP, or the TPP. Market access is an issue. Sanitary and phytosanitary measures dealing with food safety and geographical indications are now the big issues. And all three of these issues are present in the three agreements, but with different emphases and different significance. So what I'm going to do is I'm going to take each of those issues and talk about how they're playing out in each of the agreements, then talk a little bit about what those agricultural issues mean for the agreements, and then what do the agreements mean for the multilateral trading system, at least with respect to agriculture. Market access is the agricultural issue in the TPP for the United States, but not only the United States, and in this case there is one subject, and that's Japan. Canada may become a subject down the road, but this is sort of the key sticking point. CETA saw some liberalization on both sides, but if you noticed in Colin's presentation, there's 100% liberalization of merchandise trade. Agriculture, there's still some protections. The Canadians did not give up on supply managed goods. There's a little bit of a slight liberalization with respect to cheese. The EU is going to phase in tariff reductions on grains. So not quite what everybody thought was going to happen. TTIP, at the start, no one thought agriculture was going to be a big issue. Supposedly, we trade different agricultural products. Americans export commodities. The Europeans export high-quality foods. But the early offerings on market access were less ambitious than people thought. And so there are sort of echoes of the CETA story in TTIP on agriculture. Now, sanitary and phytosanitary measures are the agricultural issue in TTIP for the United States. And the U.S. agricultural industry is frustrated with the incapacity of the WTO to resolve disputes over veterinary drug residues, hormone-treated beef, the approval of varieties of genetically modified organisms. Despite winning the complaints, EU policy has not changed sufficiently to appease U.S. farm interests. So they see TTIP as the last best hope for addressing these kinds of regulatory differences. You also, in addition to GMO varieties and veterinary drug residues, there are also antimicrobial treatments. That's a big issue for Georgia, the antimicrobial treatment of chicken, but also pesticide residue levels, which are a big issue for lots and lots of different U.S. commodity exporters. Some agricultural interests in the United States have threatened to try and block the agreement if they do not get the EU to actually change its rules on some of these issues. By the same token, the European Commission, the Council of the European Union, and the European Parliament have all made it abundantly clear that the EU is not going to change its food safety regime. There may be some scope for addressing issues at the margin within the existing framework, and this is kind of what CETA suggests. The Canadians are actually quite pleased that they got anything, but its commitments on the EU's commitments on food safety and CETA come in parallel letters to the agreement, so they're not part of the agreement, and they basically are commitments by the Commission to do what it can within its scope of existing autonomy. So it's going to try and move applications for genetically modified varieties of canola through the approval process a bit faster, so move it between the stages. And they're also going to try and get the Council, they're going to advance a proposal under the common comitology procedures to try and get acceptance of recycled hot water as a carcass decontamination technique. This is the really sexy stuff you get stuck, you get stuck into as it, makes you reflect on, oh my God, I'm not going to eat again. Anyway, there are discussions on SPS in the TPP, but this is much more about trying to sharpen WTO disciplines, emphasizing the need for science-based measures, risk assessments, ensuring the measures are least trade restrictive, and ensuring transparency. Here, the United States is resisting including at least parts of the SPS provisions under binding dispute settlement. Because here the United States wants to preserve the regulatory autonomy of U.S. regulators. So here the U.S. is, in TTIP, the U.S. is the aggressor. In the TPP, the U.S. is the defender. And then we have the issue of geographical indications. These are things like feta cheese, Parma ham, Black Forest ham, Parmesan, and various wines and beers and things like that. Geographical indications are the offensive agricultural issue for the EU in TTIP, and they were a major issue in CETA as well. The ostensible aim is to offset any concessions on market access through securing competitive advantage for high-end food products, so giving EU agricultural interests a win. U.S. agricultural interests are vehemently opposed to any concessions on geographical indications. As part of CETA, Canada agreed to various ways of addressing 179 different terms covering food and beer, but a lot of these are, there's quite a bit of variety here. Some, like Black Forest ham and Parmesan, will continue to be used as has been. Feta cheese and some other things, future users will have to call them feta-like or feta-style, but people who've already been producing feta in Canada will be able to continue to call it feta. The Canadians will be able to continue to use customary names for plant varieties like Kalamata olives, and they can continue to use the parts of multi-part terms, so Brie de Mieux would be covered, but Brie is not. Right? So this is kind of, and this, so this is sort of the issue going on there. I was quite surprised to discover that geographical indications appeared in the Trans-Pacific Partnership negotiations at all, except that they are there because the Americans are trying to prevent the Europeans' protections of geographical indications in their bilateral agreements with TPP members from restricting U.S. agricultural exports. So Trans-Pacific Partnership is a battleground between the United States and the Europeans over the use of geographical indications elsewhere in the world. So what are the implications for these agreements of these issues in agriculture? Well, CETA reveals that there was a lot of compromise on agriculture, right? Nobody got nearly what they wanted. The EU did not manage to crack Canada's supply management regime and did not get a clear-cut win on geographical indications. It got a bit, but well short of what it would really have liked. Canada did not get much progress on the EU phytosanitary measures, and there was delayed liberalization of market access for grains. So pretty modest on agriculture. In TPP, the agriculture is the critical issue on Japan's participation. New Zealand is not just for the United States. New Zealand has been talking about kicking Japan out of the negotiations if it doesn't give ground on agriculture market access. Without Japan, TPP isn't worth a huge amount to the United States in terms of market access. And maybe it's the make or break issue for TTIP. With the U.S. agriculture industry demanding progress on SPS, if they are sufficiently dissatisfied with the outcome, would they really go ahead and try and block the agreement? The EU is almost certain to grant very little, not much more than the Canadians got. So there's a question about how much opposition there would be in the United States to an agreement. What does all this mean for the wider issues? To an extent, the agriculture negotiations are sort of pushing in the lines of, if not where WTO rules are, where they were kind of getting to in the DDA. The Doha round was seeking to enhance market access. So the deals are pushing further on agricultural market access. You have existing WTO disciplines on SPS measures. Sort of the view, certainly from the United States, is that these disciplines are not effective enough, and so there's an attempt to try and tighten them up. The efforts are kind of in line with WTO objectives. The CETA agreement did not go much beyond SPS. TPP is very much about trying to give more substance to those agreements. And the thing is, if you do get greater agreement on, say, between the United States and the European Union on agricultural standards, Yuri was saying that the common standards will present problems, but for other countries, because they'd be high standards, well, in this case, they might not be such high standards, they might actually be lower standards. But in any case, if you're only dealing with one standard to access two large markets, that might be better than dealing with two different ones, one of which would be high. And geographical indications are something that the EU has been pushing for within the multilateral trading system, running into constant opposition to the United States. And we sort of now see these agreements in CETA and TPP as the battleground now taking, it's the same battle, but now rather than being within the WTO, is now occurring through mega regionals. But the thing is, I really don't see much in the way of common rule setting. Right? So there's not going to be an issue for political legitimacy for international standards being dictated by the EU and the US, because they're just not going to be able to reach them. But the thing is, that also means there won't be the advantage of simplifying exports. Market access will also be less than advertised. But what there is will be trade diverting, but it's not going to be all that much, so it's not going to be terribly trade diverting. But it's such so the agricultural aspect of the mega regionals doesn't seem to have huge negative implications for the rest of the world, and one might wonder whether agriculture has become the stumbling block to the mega regionals, whether or not mega regionals might be the stumbling block to multilateral trade system. Thank you.
Thank you, Alistair. Your points about geographical indications raised for me the intriguing notion that we might have trade agreements that conflict with each other. So Canada might promise the EU something in CETA that is inconsistent with what it promised the US and others in NAFTA or the TPP. And as a sort of commentator and blogger about these issues, I'm looking forward to it. I don't think it would be very good for the system, but we'll see what happens. Our last speaker is Josh Meltzer, talking about data privacy and data flows. Hopefully he has a way for all of us in America to engage legally in internet gambling, which we've been prevented from doing for a while. Go ahead, Josh.
It's not legal. Shit. I'm going to talk, so I'm just going to do my presentation with a little bit of a focus on the US and the EU, partly because of the TTIP negotiations, but I'll broaden this out a little bit beyond what's happening bilaterally between them. And it's, one of the good reasons, of course, is that when we talk about the US and the EU, we're talking about the world's sort of two large economies. It's approximately 50% of global GDP, 25% of exports, 30% of global imports, and also significantly, and this will come out a little bit more in my presentation, is that the flow of foreign direct investment between the US and the EU is the largest in the world. There's stocks of almost $4 trillion in FDI between the US and the EU. From a trade perspective, they're both each other's largest markets for goods and services. And so what the US and the EU do on this issue matters for themselves from a bilateral trade and investment perspective. It's also going to have global implications. So this graph here is an attempt to capture data flows. So data flows, what we're talking about here is we're talking largely about sort of what happens over the internet. And this is a map essentially of the submarine cables that carry data and enable the global internet to operate between some of the major regions of the world. The way it's essentially divided up is you have submarine cables with a certain potential laid underneath the oceans, and then a certain amount is essentially turned on and a certain amount is used. The ratios tend to be the same. I mean, the significance here really is also just getting a sense of the magnitude of the data flows between the different regions. Now, I need to I throw this out as a sort of a caveat because there are limitations here and there are a lot of challenges in actually capturing these data flows. Part of it is just the nature of the internet, which means that from an end user to end user perspective, it's actually very hard to work out, for instance, when you look at transatlantic data flows, whether we're talking simply about data between US and EU citizens. There's a lot of data that, say, for instance, transits from Latin America in order to get to the EU. So if someone in Chile, for instance, sends an email to someone in Spain, that actually may go through the US and be captured as essentially a transatlantic data flow. Similarly, the way the infrastructure for the internet is, a lot of African internet traffic transits through Europe. So you might pick some of that up in that figure. But nevertheless, I think the overall sense remains true, which is that we currently, at least, the data flows between the US and the EU about 50% larger than anywhere else in the world. Now, that's, but you can still see that the data flows are enormous globally. So what's driving this data flow? Well, a lot of what's happening over the internet, there's a lot of different sources of it, but from a trade perspective, what we're seeing is the increasing ability to trade online, and this is often in the form of services. And so this might be things like financing, consulting. It might be downloading, accessing software. A lot of the cloud computing is generating a lot of cross-border data flows now. And so this is partly reflecting a changing in the way that trade is actually being able to occur online. Now, this is a very significant development for a variety of reasons. Part of it is that it's providing opportunities for people to essentially plug in and engage in the global economy to essentially become traders in ways that was not possible before. So particularly individual entrepreneurs, small and medium-sized enterprises, where are they located, as long as they have internet access, can actually become international traders. And the opportunities are fairly significant. We've got 1 billion people in India yet who don't have internet access. There are approximately 700 million people in China without internet access. So the opportunities for internet and getting online to actually underpin growing levels of trade by people who traditionally never participated in the international trading system are fairly significant here. A lot of what's going on also is this is not only about sort of businesses selling to consumers, it's a lot about supply chain management. So if you are, and this is how this sort of in part underpins a lot of foreign investment. So the opportunity to say, for instance, for large businesses to communicate internally, manage HR data, manage production schedules. So for instance, US companies doing that in Asia or European companies doing that in the US and in Latin America, vice versa, is the ability for data to flow freely is an increasingly important component of that business. Now, this is, again, just looking at the US and the EU, and what I'm going to do is I'm going to attempt to give you a sense of the importance of this by looking at specifically the services side. There's some severe limitations in the data and how we can actually understand what this actually means from a quantitative perspective, but this is sort of an attempt to get at it. This is a breakdown of what is referred to as digitally deliverable services. So this captures the notion that there are services out there which could be delivered online, that we don't know if actually they are delivered online, so that part of this is actually the potentiality for services to be traded online. The reason this has got that potential in it is because there's no data out there which actually, for instance, tells us how services are traded, whether it in fact happens person to person, or happens over the internet. But these are the types of services that could actually increasingly happen online. This is sort of a categorisation that the United States Department of Commerce put together. And you would see the types of categories that you would imagine. This is breaking down those categories for both US exports to the EU and EU exports to the US. And you sort of see to some extent what you would expect to see. The US gets a lot in terms of royalties and licenses compared to the EU, but you also see a lot of business professional and technical exports from the EU to the US. Now, another important dimension here is that, there's a lot of studies out there which increasingly show that actually access to particularly a lot of these services is an increasingly important aspect for businesses themselves to become productive and increase their competitiveness, and to then themselves either improve their positions in domestic markets or in overseas markets. So there's actually some correlations between export growth, for instance, and access to business professional and technical services. So in many respects, if you think about this again from, say, a small entrepreneur SME perspective, access to software on the cloud which can be scaled up at need instead of having to have an expensive IT department, access to, say, cutting-edge consulting services, etc., can be a very important part of your capacity to actually be productive and competitive as a small business, and a lot of times these can be accessed at lesser cost. Now, this is beginning to look at the significance of digitally deliverable services for actually exports from a trade perspective. And this is simply a first step in breaking down. These are basically US and EU exports of goods and services, and gross exports, and then there's a value-added calculation. So the gross is basically your standard trade figures where, again, I think the shares are really more interesting than the absolute values, where you see for the US and the EU, essentially, they export the same shares of goods, the same shares of services, about 2/3 good, 2/3 services. If you actually look at value-added trade, which is essentially the value of the services used in the production of goods, so we all know that increasingly, particularly in higher and manufacturing sectors, you're going to have a lot of design, a lot of R&D, you're going to have sales, you're going to have a lot of accounting, legal, and other types of services that actually go into the production of those goods, and which are then effectively exported. When a car gets exported, embedded in that car is a lot of design and R&D, etc. Then you begin to see that, in fact, the US exports a lot more services than the data captures, and the same is true for the EU. And so for the US, services exports on a value-added basis are actually almost about 50%, and actually for the Europe they're even higher. And so we begin to get a sense at least of the importance of services here for both the US and the EU. Now this is just taking it a step further and actually looking at both in terms of percentage of overall exports and also just in terms of sheer value, what the digitally deliverable component of that is. So you see for the US, for instance, you've got gross exports, say top left-hand side of digitally deliverable services is about 20% of total exports, but if you actually look at the value-added components, you actually see that you get larger and more significant shares. So for the US, it gets up to over 30%, and then you get that. I've just given you that in actual figures for what we actually had, and then similarly for the EU. So for the US, it's about okay. So this is now just picking up digital eligible services for both the US and the EU to different regions in the world, and so you begin to get a sense of the importance of this from a trade perspective. So here we've got total digitally deliverable services from the US to Europe. I've broken up into Europe, EU, Latin America, Asia, and to the world. And similarly, I've got that for the EU, and that's basically, so you've got the top there's giving you as a percentage of their total services exports, and then I've just written in the absolute values into the actual bar graphs. So for instance, you see that for the US, digitally deliverable services to exports to Europe are over 70% of total services exports. And you can see actually when you break it down, for Ireland, for instance, over 90% of US services exports to Ireland are actually digitally deliverable. And even for countries such as France and Germany, they're over 60%. And part of this also picks up the fact, and this is the point I was making before about the services as inputs, is that this is not an IT issue. This is if you are in the auto industry, if you're in the manufacturing industry, if you're in the retail industry, you are digitally enabled. You use the internet for a variety of important purposes. So this is an issue that cuts across all economic sectors, which is why Ireland is so high essentially because a lot of data servers and data storage facilities are located in Ireland, so you get a lot of actual data flows between the US and Ireland. The UK is high partly because of the financial services sector there and a lot of the financial flows that happen between the US and the UK. But France and Germany, which tend to be more, so for instance, you think about Germany, you think more about sort of like the higher end manufacturing, cars, etc. It's still very important for those economic sectors as well. This, I won't spend too much on this graph, it's very colourful and a little bit complicated, but essentially what it's picking up here is the idea that, and this is sort of a point I kind of do repeat, which is that, again, it's talking about business to business, digitally deliverable services, and essentially the idea that you actually, if you're in the US, what you actually tend to do is you import, say for instance, some cutting edge business services from the EU, you use to produce other goods and services which you then further export. So in fact, this is just the point that the free flow of data is also about enabling further trade from these countries to the rest of the world. So this just breaks down, for instance, for goods and services exports for both the US and the EU, what component, in a value-added sense, what component of, say, total goods exports is comprised domestic goods, imported goods, domestic services and imported services, and then it breaks down the imported services into what share of that is from the EU and then what share from the EU is digitally deliverable, and it basically does that for goods services and goods services for the US and the EU. So both economies, and you get a sense basically of this is not only important in terms of total trade, but it's also important in terms of enabling additional exports from both the US and the EU globally. My final graph here, I just want to pick up the investment side of this. I mentioned this at the beginning, but basically, the investment relationship, as I sort of said, in many respects actually dwarfs the trade relationship. And this graph tries to show you that. So you've got on the left US services exports and imports, and then you have basically the broken down into what's services and what's digitally deliverable, the digitally deliverable being sort of the white line part of the bar. And then it's got it for services supplied through foreign affiliates. So it's basically instead of actually exporting that service directly to the other country, you set up a business which then provides a service in that country. What share of those businesses that are providing those services are doing it in a digitally deliverable sense? And then it breaks it down. So this is sort of the US sort of globally, the first four graphs, and then it's the US to Europe. And you see that essentially for the US exports of digitally deliverable services globally through investment, and also into Europe, that the investment components, which are really the dark blue graphs, outweigh a significant margin the investment relationships. And so when we think about this and the broader sort of economic significance, we have to look at both the trade component and the investment component. And this is a formula which plays out not only on a transatlantic basis but also broadly more globally. So this leads me to talk a little bit about. So what we have this is just about the importance economically from a trade and investment perspective of data flow. So then what are the challenges that we have out there? What's the issues from a trade perspective? Now. There are a number of them, and I'm not going to go through them in any detail, but I'll run through some of them, and then I'll talk a little bit about what's trying to be done to maintain the current system as it is. Privacy is a key issue out there from a data flow and internet perspective. It's interestingly enough, it's not something that's really come up in the TPP negotiations, but it's certainly been alive in the transatlantic sense, and it's still an open question to what extent it's actually going to be specifically dealt with in the TTIP negotiations. But essentially, Europe has a data privacy regime which applies to personal data, which basically prohibits the transfer of personal data outside of Europe unless the other country receiving the data has more or less an equivalent sort of regime for protecting that data. And if it doesn't, there are a couple of other mechanisms it allows for the transfer. One is it allows companies, conglomerates, to essentially establish rules amongst themselves for protection of that data, which would give it the same level of protection as if it was in the EU. And there's a way of doing it essentially through contract. But more or less, any type of data that is sent outside of the EU needs to basically maintain the same level of protection as under the domestic EU regime. Now, this covers increasingly an enormous amount of data because, when you think about any data which can potentially be used to identify an individual is basically it falls within the definition of personal data. And in many respects, the EU is moving to a tighter and more sort of holistic and consistent approach across the EU. This is currently being managed under what they call a directive, which is essentially still up to the individual member states to implement. So we get a lot of differences in implementation and differences in enforcement. But I think it's clear, at least from the information that I've got, that we know that they're in the final stages of what's called a regulation, which will then be an EU-wide sort of EU enforceable approach, which is expected to be passed, sometime this year. And so, this has become one very significant issue in terms of, just data flows generally. And the US in particular has got a very different process for managing the privacy of data. It essentially, for the sake of simplifying, requires companies to protect the privacy of personal data with an enforcement generally by the FTC of those commitments. So it requires privacy policies and for them to be made transparent and for penalties for breach. Now, so there's no omnibus sort of top-down approach to data privacy in the US. Now this posed a very significant challenge for the US and the EU because essentially the US did not comply with the EU approach to data privacy. This has been sort of resolved in the form of a safe harbour framework, which is being renegotiated at the moment, where essentially Europe agrees to recognise the US approach as more or less giving an adequate level of data privacy protection. But this is an ongoing issue, and this is only a framework for the US and the EU, not for the EU and Asia, etc., etc. So it's going to be true more broadly. Other issues which are out there, we're seeing a lot of discriminatory sort of practices by some nations in terms of access to online businesses. I mean, China's a great example where you can't get access to the New York Times, Google gets redirected to Baidu, Facebook and Twitter get closed down, etc., and often just to, help domestic competitors. And part of it's also there's political issues associated with access to data. I mean, we see, for instance, in Turkey, Twitter got turned off during the range of revolutions that sort of happened across the Middle East. Access to Twitter and other social networking sites were periodically shut down. So there's that there as well. And for some countries as well, there's sort of a moral issue in terms of do you have what type of pornography can you access online, free speech, religious sensibilities. These types of issues often lend to forms of censorship, which affect data flows globally. So this has become I think hopefully making clear here, a significant trade and investment issue, though it's not only a significant trade and investment issue, obviously bringing in other values. And, the US has been spearheading the approach in trying to get at this. Now, the Korea-United States Free Trade Agreement was really the first time in a way that this was sort of put into binding trade rules where there's more or less a commitment to free flow of data with exceptions. It's not a binding commitment of the way the language has been framed, but it was the first attempt to get at it. And this is where I think the TPP will be particularly interesting, because I think we're going to see there a much sort of stronger sort of full court effort to get more binding, stronger disciplines around maintaining open sort of regime for the internet and data flows, while recognising that countries are going to have to regulate data flows in some instances, but it will bring in probably quite well-known trade concepts like least trade restrictive, non-discriminatory, etc., to try to discipline the ways that this happens. But this is very much an alive issue. Thanks.
Thank you, Josh. It's amazing to me, 20 years or so into the whole sort of internet revolution, we're still discovering new services that can be traded online that we didn't initially think of. So obviously the last couple of years, online education has been big. I think healthcare services online is going to be something that we discover the next couple of years. And once it can be put online, then it can also be traded internationally, and then something else we get to talk about here. So we've got some time for questions. I think maybe I'll kick things off with one, exercising my moderator's privilege here, and then turn it over to people in the audience. Sean and I were talking at the break, and I just wanted to kind of push forward with this conversation because I think it's it's broad enough that everyone might be interested in it. And we were talking about transparency, and there's a lot of conversation about to what extent should negotiators disclose the text they're working on. And I was a little skeptical about it, and he's making an argument that you could do it. And he mentioned this. He referred to the way things work at the World Intellectual Property Organization, WIPO, where texts are put out there for discussion at certain stages. And it's a dangerous question for me to ask because I don't know his answer and it might undermine my argument, so maybe I shouldn't ask, but I'm going to take the risk and say, is it possible that at WIPO, when you have these negotiations where, as you say, the texts are circulated and discussed periodically during the negotiation, is that because what they're negotiating is a softer form of law? It doesn't have binding dispute settlement. It is to some extent, and I know this is controversial, less important. I mean, that's a dangerous way of saying it, but it's just it doesn't have the implications that trade agreements do. And is that a reason why they're more comfortable with transparency in that context?
Well, I don't think that's the reason why. So the differences between, for instance, a free trade agreement and a WIPO agreement as far as enforceability. So there is within the trade agreements, there's a state-to-state enforcement apparatus, but of course that exists in the WTO too, which is also a more transparent institution than free trade agreements, although less transparent than WIPO. Excuse me. So at international law, what WIPO is negotiating are treaties. So they are, fully binding agreements.
They're binding, but are they enforceable? Do they have a dispute settlement mechanism?
They don't have a dispute settlement mechanism built into them. That's very true. Although, if you look under the bilaterals, none of the bilaterals has gone to dispute mechanism. The only aspects that have ever gone are actually extremely controversial, which is investors bootstrapping IP into investor-state dispute. But I would argue that I don't think those were originally intended within the agreements as well. So the Eli Lilly versus Canada case, for instance, where Eli Lilly is arguing that it lost a patent validity suit within the courts, and it's now bringing that through NAFTA's ISDS. But the IP provision within NAFTA is not explicitly subject to the investment state dispute clause. So it's a big leap. It's an example of very aggressive lawyering, the possibility of which is opened up by these kind of agreements, but I don't think they were envisioned in the original agreement. So the original agreements, intellectual property is always nested within state to state, which actually has its kind of built-in checks and balances. It still lives in a little bit of the diplomatic world as opposed to the ISDS world, which is certainly more aggressive. So I'm not sure. I don't think that's why countries are more willing, or why the United States, for instance, is more willing to have transparency there. But I think the argument from the United States is different. It's that if you look at what WIPO is able to accomplish, it is way more targeted. So they actually, if you look over the last 10 years, have accomplished more. So there are 2 treaties that have gone through WIPO. There are 0 mega regional agreements that have actually been ratified. So it's 2-0 right now on WIPO versus mega regionals. But what they did was Beijing Treaty just on performers' rights. So it's not shooting with a shotgun. It's shooting, with a sniper. Or Marrakesh Treaty is just on limitations and exceptions for people with visual impairments. The WIPO Internet treaties were broader, but again, just on copyright. They didn't bring in the patent and everything else. But I would argue that's a virtue, not a flaw. That, I think as one of the speakers on the first panel was saying, that these mega regionals are so much harder to do because they're not just on tariffs, they're on all these regulatory issues, and they're on the regulatory issues about everything, So it's all parts of IP. You're going from geographic indications to patents to enforcement at the border to copyright to e-commerce to, all of these issues are there. And so, and the way they've kind of dealt with that is say, well, we can't do it in the open because we'll never get it done. I agree. I don't think you can get that many issues done in the open. But I also think you can't get them done in the closed either. Because eventually you got to release the thing, and then it all hits the fan, and then you can't ratify it. So it's a two-edged sword.
Yep. Any other comments on that, or just general questions? Question right there.
Thank you. So it seems that part of the problem this panel is addressing is a disparity between the perceived value of these concessions to the constituents of the respective parties and the actual value that would appear to them if they were made. So, the difference between the value of champagne over sparkling wine isn't particularly great when most of the value is in the mark of the company selling it. And similarly, if you're going to sell a one-day version of a drug and there's a 3-day generic, then really your value is going to come out of sales and marketing, not necessarily the intellectual property protection of that one-day version. And so are some of these concessions really about disagreements between the decision makers, or is it really a need to educate the public about having a more realistic understanding of the value of the agreements?
Good question, which I'll turn over to the people who talked about IP to see if they have any thoughts.
So, maybe I'm inclined to bicker on the premises a little bit, so that for the drug example, for instance, I was talking this with a consumer's advocate yesterday, and she brought up that kind of question. Well, if they patent the new use, right? But then the generic can still be on the market, right? So the strategy is you patent the new use, and then you take the old one off the market. right? And so there can still be a generic, but now, as you say, all the value is going to be invested in the marketing. So now you're going to convince all the doctors to, instead of writing, I don't know what the two drugs are called, Apogen and Betagen. So now you're going to tell them all to write Betagen on their prescription. So when they do that, you bring in, so Betagen is patented, Apogen is not. They write Betagen, then usually the state substitution laws will not allow you to substitute the 2-day version, the 2 times a day version with the Betagen, and there is no substitute for the Betagen. So now you have to figure out a way to make the doctors write the old name on, and probably change your laws to allow it, or to actually write the generic name of the drug on the prescription, which they never do. I also just happened to get a prescription yesterday. Of course, they write the brand name. They gave me the generic, but that's because of the substitution laws. But doctors write the brands because that's what they marketed. So they know the brand names. They trust the pharmacy to change it with the generic. So if you accomplish the kind of patent on the new use, your bet is you may not keep all the market, but you're going to keep 90% of the market under the new patented formulation. So whether you can get a patent on that formulation actually really does affect the value. You're right in that it affects the value through the capacity to market, the capacity to get your market share through marketing, but you're enabling that marketing only because of the patent law. So if you would have not had the new use and you just let the thing go generic, then usually what happens is the brand pulls out of the marketing. The doctor keeps writing the brand name and it gets substituted with a generic. The brand share of the market goes way down, and they invest their R&D in something else. So it completely changes the way pharmaceutical companies invest.
All right, well, I've got 2 questions from 2 of our live stream viewers. So the first question is to Joshua Meltzer. Can you comment on the US-EU PNR and safe harbor framework post Charlie Hebdo? And then the second question is to Alistair. Regarding agriculture, we've seen with NAFTA and CAFTA that smallholders and family farmers have been pushed out of agriculture, not only in Central America and Mexico, but also the US and Canada, and that primarily large agro-industries have benefited. How will current treaties under negotiation impact small-scale farmers? Should agriculture still be included in these sort of treaties?
Let's start with Josh.
So the main, it's an interesting question. The main issue that has been holding up the framework negotiations really has been the security dimension to them, which has essentially been around how the US government accesses data for national security purposes. And this is really a continuation and to some extent, a blowback from the whole sort of Snowden issue. And the US, in fact, government has been trying to get legislation through Congress, and there was a bill which the Senate did pass, which sought to address that more specifically. It hasn't passed the House, and I think there's going to be a renewed push to do that. Now, I don't know how what happened in Paris affects that. I mean, to some extent, it's not probably related, though I think if you look at it's certainly not related, but I mean, if you look at the climate and the context, the importance of, it's difficult, right? Because the importance of essentially good policing and security work is increasingly going to require a certain amount of online monitoring, and particularly when it comes, I think, to these types of activities. I've got no idea whether that would have prevented this happening or not, but possibly it changes the context in terms of which that part of the discussion plays out.
Well, it's I actually didn't get to come in on the first question, but I can link the two, I think. In terms of the issue of the value of the agreements, right? And the argument for the geographic indications do benefit the consumer in the sense that you're guaranteed a higher quality product. You know that it's better. right? Now, you may not find a difference between champagne and sparkling wine, but that's the argument. Market access supposedly provides benefits for consumers by lowering prices, but that's not transparent. And what you're seeing, I think, with the issues coming about things like food safety, people care about that, and they don't. So you have part of why you're having opposition, particularly in Europe, though you have actors in the United States who are concerned about the agreement compromising food safety here too. There was a Pew study that found that both Americans and Germans preferred their food safety standards to that of the other side, right? Because it's what you're familiar with and what you trust, right? So the issue is, if you think there's a there's a risk of reduced safety from an agreement on food, you don't really care about any price gain, right? It's not a trade you're willing to make. Now, whether there would be that safety gap is another story, but that's the concern, right? And so that's part of where this issue about for publics, what are the benefits? They're going to be pretty opaque. Right? That's what true of any trade agreement. The difference with these kinds of trade agreements is they touch on issues that do resonate with people. ISDS and environmental protection, issues to do with patents on pharmaceuticals, issues to do with food safety do resonate with people. Right? So I think that's part of why you've got more of a, there's the politics of these kinds of negotiations is much more complicated than a traditional. That's just at the public level. When you start adding in the issues of having to get regulators to agree to do things together when they have different mandates and different folk on it, it gets even more complicated than that. Right? In terms of the agriculture back, I was saying earlier, I'm not really an agriculture trade person. I come at this from the SBS side, but I'll give my best fit, at least try and answer the question. I mean, in both the United States and the European Union, the domestic policies overwhelmingly privilege large agricultural producers. Domestic policies do that. The trade policy is being driven by the large agricultural producers. Whether it would make things any worse, given the status quo, probably not to a noticeable extent, given the different forms of exports, the differences in the agricultural exports of the two economies.
Any other questions? No?
Hello. I had a question for Professor Young, actually. It's sort of a question about culture and another sector that has been contentious in transatlantic trade, the audiovisual sector. From what I understand, this has been carved out of TTIP. But I was just curious if you see any parallels between your sector that you've talked about, for example, what you just mentioned, the GMOs or the rules of origin, and then a country like France heavily subsidizing its film industry to the detriment of U.S. film, for example. Or I was just curious what your thoughts are on this area.
Well, I think the culture argument is a bit simplistic, and there are more subtle reasons for the differences. But in terms of audiovisual services, the French government have insisted they not be included in the negotiations. My understanding is the French are fighting the last war. The Americans don't care about the subsidies anymore. They want to talk about piracy. And so they're not, if you look at the MPA position paper on regulatory cooperation, there's no mention of all of the domestic subsidies and content requirements. It's a bit like that in agricultural biotech. They're not talking about cultivation. They don't care anymore. They've given up. Right? They care about market access. They don't care about cultivation. Just they figure that battle's lost. It's not worth fighting anymore.
Any other questions or time to? Well, it's 2:30. I don't know. I have.
We're probably, you're the chair.
I'm I'm in charge. Okay. Okay. Well, I wasn't here for I was here for about half the beginning. The part of this I saw has been very good. I hope everyone else had a good experience and learned something here. Thank you to the panelists on this panel, and thanks to the organizers for organizing. And if the organizers want to come up and say anything final, they're free to do that. But if not, I think that wraps up. Let's give a hand to this panel.
For those on live stream, we're ending our session. For those of you who would really like to hear these presentations, they'll be up for another week. And we will be distributing them to EU trade officials, to the embassies, to the EU centers across the United States, fair use. Thank you very much. Any questions that come on live stream or singlemarket@american.edu, we will try and answer for you. Thank you. It was really, really nice. We actually had, over the course of the day, 100+ people live streaming here. So we actually probably had a live stream. We don't know if that was an individual
The ones that they posted
or
online
a
recently?
class.
I glanced at them and that was useful. I mean, they're a bit older. You didn't get the sense you have the most recent, but it was something official. So I thought it was nice. I was glad they were doing that.
Because we had 55 people signed up, but any other issues.
Yeah, it's
The live stream was huge.
Yeah, no, absolutely. I was watching it actually from home, that's why I came off.
So that was for us, and it'll stay up for a week, so we're sending it out every
Right,
Member states
right.
can look at them,
You know, that
they
was
can't take them
We
away.
can't. I know.
They don't have a
yeah,
permanent
yeah,
address
yeah.
to it?
We're going to.
Yeah.
Oh, we'll have it on this week.
Oh, and then we'll.
You know,
I just got it up. Are you,
as an outsider in the process, I mean, I'm happy to get leaks. I'm happy to have everything disclosed, so I can see it. But I do think that if you're on the inside negotiating it, it just you feel like you negotiate with everybody. You know, if you put it out there, then the whole world can comment on it.
Yeah, I mean, certainly kind of it, yeah.
It just falls apart, yeah. So.
But it does, it does wait. I know very little about it because of legal.
Yeah.
So that must be similar to what they're starting with. So I've heard it described as kind of a right. What do you think of the deal? Do you have any kind of whether it's critiques of the things you would change? I mean,
It was a really interesting step, so it was sort of using literary language. There's a bunch of issues in it, so I think there's a lot of kind of work that has been done since then, and I think they've made some good progress. I think we will see. So I think the ball now moved to the transatlantic to some extent different.
there you have a big battle, right? Yeah, it's the privacy versus the data access. And the tech companies are very concerned with this kind of privacy rules. We have to a private data.
And it's really not clear how to take it. Yeah.
Great. And then, but in TPP, there's not that. Right. The nuance there, it's more about like, do some of those countries requiring the housing of data repositories?
They do, so this is some data localization issue. We put some language, I think, in TPP to get it's a little bit, it's kind of, sometimes it's related to privacy because sometimes regulators think they need the data to be stored, but often sort of these kind of concerns about more broad concerns for security of data. I think it's sometimes safer, and sometimes there's law enforcement concerns that if they need to get into data, or an organisation, bring it back to the country. So certainly countries have gone down that path and looked at introducing data localization rules and trying to get things. Yeah.
Well, it's nice to know someone following. Do you have your card?
Yeah, absolutely.
A lot of the kind of folks and groups I work with are mostly focused on the IP stuff, but like should be interested in the data stuff, but probably don't know a lot about it. Who else works on like e-commerce from a neutral or kind of NGO standpoint? Is there a little network around that issue?
There is a little bit. I mean, there's obviously a lot of companies who are engaged.
I know the folks at CCIA, for instance, although I know talking to Marty Myers, but I assume from CCIA. The Computers and Communications Industry Association.
Oh, yeah.
So it's like Matt Schurz is kind of the, I think he's their
vice president for international relations. I deal with him on the IP stuff. I haven't followed the conversation. But Google and Facebook and Yahoo and those guys are all members. They're members of 1,000 things. But I think that's one of the organizations that tries to them and the Internet Association, I would say, are the two that probably kind of try to drive that opinion the furthest forward. But Microsoft is also a member. It's not. There's never just kind of one voice, and it's not just internet. But they started out as. I think some of their original clients were, like Sony, Betamax stuff. They were always kind of in the copyright debates back in the day, 76 copyright format, that kind of stuff. So I think they always position themselves as the innovators, on behalf of the innovators. And so that's kind of the position they have in Congress and international stuff.
I got the impression when you were talking, this whole the digital, the DMCA is very sensitive. Do you not like the balance that's been struck there?
There are some parts of the balance that I think are horrible, including for U.S. law. So technological protection measures, for instance, is it needs complete reform, and probably we should get rid of it. The way it's structured is you don't actually have to have a copyright violation. All you just have to have a copyright protected thing. So, for instance, I tweeted the other day, I just bought my kid a Nintendo Wii or whatever, and its license agreement says that you cannot modify or do anything with the console you bought, not just the software. You can't even touch the console because it's protecting the software that's inside of it, and we retain the right to modify it without permission. All this stuff. So I signed it, and okay, I want to play the games, but it's it's insane. And there's all these cases where most of the cases are about anti-competitive uses of that right. It's not even about breaking open movies to copy them and create piracy. So I'm not pro-piracy, but I'm very anti the use of that tool for anti-competitive reasons. So you have to amend that to change it. But it's the elements of that law are in at least 15 of the bilaterals. So technically you have to renegotiate.
No, you do. That's right. I was working for in Australian Foreign Service when we were negotiating the TPM in the US.
Yeah. Okay.
And
Cool.
that TPM issue was enormous for us. It's really.
So it's so specific. Where if you just went back, so in the WIPO internet treaty, so that was a controversial issue when it went into the WIPO internet treaties, but it's 40 words. There's a lot you can do there, including tailor it to copyright violations. It's totally in compliance with the WIPO internet treaties. If you just say, it's illegal to break the code in order to illegally copy. But now you can do it. You can be illegal to break the code just to re-engineer a compatible device, which is that cuts down on innovation and competition. So there's lots of stuff I would get rid of. And then on the how we deal with infringement on the internet, like the notice and takedown type stuff. I think it's a folly to think that we figured it all out and this system will have for all time. There's aspects of it that might be okay. There's aspects of it that don't. The problem on the political economy perspective is companies like Google, they're as long as it's just a system, we're already complying with the U.S., so we don't really care if it globalizes. But I think they're being a little short-sighted because it's if you had the political will to change it, now you can't. You come up with something better. And you don't know what better is, but you guys are engineers. What if you just define a better way to do it? Because right now it's this robot versus robot thing. It's kind of a silly system. And then it disadvantages, to some extent they're treating themselves like a company because it disadvantages the more local players who want to become an ISP. It actually protects their position because they're such a big piece of the pie. So
when you think about the right to
privacy issue Google case, in Europe.
freezing it, it's attempting to freeze in place and export the US system. That's not a good idea. Always a
I have to go teach. Okay, so on the break, I have to teach. So I'm going to leave you guys. Thank you. I'll be in touch. It was really quite interesting. I teach. I'm currently teaching a crisis class. I teach break the brick, and then I teach a basic class, political economy, the EU. I teach political economy, I teach international European integration, crisis, which is really a little bit about welfare, labor markets, structural justice. This matters. This is what you want. Intellectual property, What do you think? I think it's the letter. I got a view this morning and emailed me saying, staying at home and watching it. But I don't, because I work there, I don't know how to go there. Or I've never been to I don't know enough to them, they probably would. So if they're working, I don't know how to develop. All right. Thanks a lot. Thanks a lot. John, I'll probably send you something about transparency.
Cool. Yeah, I'll respond to it.
But if there were to be one, then it case could be a competitive deal from the U.S. The U.S. does the same thing.
You go to the domestic court, then you
You're with the EU?
Yeah.
The local station in DC? Or what are you covering? Just trade?
Financial services,
So you're the TTIP guy?
one of them, yeah.
I've been to around, once when it was here. The last one that was here. Great.
Yeah, I thought it will be good there.
Okay, yeah.
This was really helpful.
Cheers.
Because, yes. Now.
Promise you don't want to have a. So again, you go to ISDS if you think it's.
If all you
No, I don't know why this was moved over there.